Hello, everyone. Welcome back to the 26th Annual National Security Law Conference, sponsored by Duke's Center on Law, Ethics, and National Security. And we have a great panel coming up. But before I do that, I do want to remind everyone, if you want to support the conference and support the center, just go to the agenda website and you'll see an opportunity to do that. I'm really excited about this next panel, and you won't have to look at me because Lieutenant Colonel Amy Neiman is going to be the panelist, the moderator for this panel. She has a very impressive bio. You can see the link. If you hit the link on our agenda, you'll be able to see it in some detail. And among other things, she's a master parachutist. Still mostly in one piece, right, Amy?
That's right, mostly. Can you hear me?
Yeah, sure can. And she was a combat medic. She has a very distinguished career, and now she's head of outreach for the Army. And I sort of locked her into being the moderator for this panel. And really good to see Amy, and thank you so much. Over to you.
All right, I'm excited to be there. Good morning, everybody, and welcome to the short burst panel on law of war development. As General Dunlap said, I'm Lieutenant Colonel Amy Neiman. I'm an Army Judge Advocate with OTJAG's National Security Law Division. We have a terrific panel for you on this Saturday morning. I'll be brief so we can get right down to business, and you can find our panel's full bios on the conference website. Major Heather Tragel, who is a military professor of international law at the Stockton Center at the U.S. Naval War College, will kick things off talking about landmine policy. Heather previously served as the primary legal advisor for the Joint Operations Command Iraq, and she's also deployed in support of military operations in Afghanistan. Next, Professor Jeff Korn will discuss civilian casualty aversion. Professor Korn, as many of you know, is a retired Army Judge Advocate. He now serves as the Distinguished Professor of National Security Law, South Texas College of Law, Houston. Professor Korn is the author of numerous treatises on national security law and the law of armed conflict, and has appeared as an expert witness at the Military Commission in Guantanamo and the International Criminal Tribunal in the former Yugoslavia. Colonel Adam Oler is also here to talk with us about the limits of the law of war. An expert on how we train our senior military commanders, Colonel Oler is a professor at the Department of Security Studies at the National War College. He has over 22 years of experience as an Air Force Judge Advocate, and he's served in numerous positions, including as a Staff Judge Advocate at the Office of Military Cooperation Kuwait and as a military judge. Last but certainly not least, we have Professor Lori Blank, Director of the International Humanitarian Law Clinic at Emory University School of Law. She's here to talk about ending war. Professor Blank is the author of case books on the law of war, as well as numerous articles and opinion pieces on related topics, and she co-directs a multi-year project on military training programs in the law of war. Administratively, each panelist will give short remarks, and then we'll kick it out to the audience for a Q&A. Please submit your questions using the Q&A function. Now, Major Tragel, please get us started. I see Lori.
I forgot to unmute myself, sorry. Good morning. Thank you for having me, General Dunlap. It's a pleasure to be here. I would first like to start with the disclaimer that the views expressed here are my own and do not represent those of the U.S. Naval War College, Department of Navy, Army, Defense, or any part of the U.S. government. Since its creation, the law of war has developed over time and will continue to do so. When we talk about developments in the law of war, those developments can sometimes be grounded in policy, and sometimes they are grounded in legal obligation. Both can affect the rules that constrain the warfighter, but it's important to understand whether a law of war development is based in policy or law. A great example of this dynamic is the evolution of the United States landmine policy. Last year, the Trump administration changed the U.S. landmine policy. This decision was met with much controversy throughout the international community, as well as criticism here in the United States. The current landmine policy reversed a previous policy decision that prohibited the use of anti-personnel landmines outside the Korean Peninsula. Under the current policy, combatant commanders now have the authority to employ non-persistent landmines, including anti-personnel landmines, when necessary for mission success in major contingencies or other exceptional circumstances. The current policy reconfirms the United States' commitment to the Amended Mines Protocol while recognizing the global security environment has changed from that of a counterterrorism threat to the reemergence of long-term strategic competition. Under the policy, all geographic limitations for the use of anti-personnel landmines were removed, and the U.S. maintains its commitment to not use persistent landmines, namely those that do not incorporate self-destruct and self-deactivation features. So, while there was much controversy surrounding the Trump administration's change to the landmine policy, and since then, a subsequent change in administration, it is important to look at the underlying legal obligations that must control any landmine policy, as well as the strategic implications for any potential future stance the United States may take regarding landmines. As to the legal obligations, there are two international treaties which control the use of anti-personnel landmines. The first one being the Amended Protocol 2, annexed to the Convention on Certain Conventional Weapons, commonly referred to as the Amended Mines Protocol. And the second treaty is the 1997 Anti-Personnel Landmines Convention, commonly referred to as the Ottawa Convention. So let's examine what these treaties do. The Amended Mines Protocol does not outright ban the use of anti-personnel landmines. In fact, it regulates their use, while the Ottawa Convention essentially acts as a blanket ban on anti-personnel landmines. The United States is party to the Amended Mines Protocol, but is not party to the Ottawa Convention. Thus, while the current landmine policy does not comply with the Ottawa Convention, it does not run afoul of the United States' treaty obligations, nor would any future landmine policy be required to comply with the Ottawa Convention. So let's look at the current policy and how it lines up with the United States' treaty obligations. Under the Amended Mines Protocol, the current landmine policy enacts more protections than those required by the Amended Mines Protocol. For instance, the Amended Mines Protocol does not place an outright ban on persistent anti-personnel landmines, and in fact allows persistent landmines to be used under specific circumstances. However, the US policy completely prohibits the use of any persistent landmines under any circumstances. Further, the Amended Mines Protocol only requires that remotely delivered anti-personnel landmines outside of marked areas self-destruct and self-deactivate within 30 days of emplacement, while the US policy requires all landmines, no matter how delivered, to be designed to self-destruct within 30 days of activation. Thus, the current landmine policy complies with its legal obligations under the Amended Mines Protocol, but also as a policy decision provides more protection than required by international law. Even though the movement to completely ban the use of anti-personnel landmines has considerably grown under the Ottawa Convention, a blanket prohibition hasn't emerged as customary international law that would enjoin the United States' continued landmine use. For starters, while the majority of states are party to the Ottawa Convention, significant states such as the United States, Russia, and China, all of which are permanent members of the UN Security Council, and over 30 other states are not party to the convention. Further, some states party to the Ottawa Convention have reserved the right to conduct combined operations with non-party states that continue to use anti-personnel landmines. This is significant because it demonstrates that even those states which have agreed to be obligated under the Ottawa Convention recognize that the treaty's prohibitions are not binding on the non-party states as a matter of customary law. Lastly, while the ICRC does not have the authority to say what is and what is not binding under international law, even they have conceded that a blanket ban on the use of anti-personnel landmines doesn't reflect customary international law. While the United States, under the Obama administration, previously indicated a potential desire to accede to the Ottawa Convention, that decision, while based in aspirational goals of eradicating all potential harm from landmines, was grounded in policy, not legal obligation. Further, the global security environment has dramatically changed since 2014, when the Obama administration indicated the goal was to move into compliance with Ottawa. Since then, the strategic posture of the United States has shifted from that of a counterterrorism, counterinsurgency fight with non-state armed groups to an environment of great power competition and the need to ensure that the United States is prepared for any potential contingency involving state-on-state conflict with potential near-peer adversaries. Anti-personnel landmines can be an effective tool in conventional warfare, and they provide a critical capability to commanders on the battlefield. They can act as area denial systems that obstruct and channel, delay, or stop a numerically superior adversary and prevent them from outflanking friendly forces. Potential rivals, principally Russia, China, Iran, and North Korea, have been unwilling to accept broad restrictions on the use of landmines. It makes little strategic sense to cede the advantage on the battlefield to potential rivals, especially when the United States is not legally obligated under international law to do so. Nevertheless, the current landmine policy demonstrates the United States' commitment to the protection of civilians, as the policy is grounded in the foundational principles of the law of armed conflict. Those principles will continue to inform any use of anti-personnel landmines on the battlefield. So, the United States' position regarding landmines has certainly evolved over time, and thus the law of war for the warfighter has changed with it. But in the end, the current policy is just that. It's a policy decision of a previous administration. If the Biden administration changes the United States' position regarding landmines once more, it will also be a policy decision and not due to any legal obligation under international law. I look forward to a discussion about the policy and any questions that those in the audience may have.
First and foremost, let me thank General Dunlop and all of the organizers, especially the organizer of our panel, for this opportunity to share some of my thoughts on what I think is one of the most important aspects of the evolution of the implementation of the law of armed conflict for the armed forces in the near term. So I guess the general topic that was listed on the program is civilian casualty aversion. In fact, I would use the phrase civilian risk mitigation. Aversion and prevention is often used in the context of mitigating the risk to civilian harm, and I think that it has a potentially corrupting effect on the understanding of the law because it actually contributes to a post hoc expectation of assessing compliance. And as I'm sure almost everybody that's participating today knows, the real obligation of commanders is to implement measures to mitigate civilian risk, and they should not be held to a effects-based condemnation system. The effects of armed conflict and the effects of lethal strikes and non-lethal strikes are certainly probative of the commitment to civilian risk mitigation, but they are rarely, if ever, dispositive. So what I want to do is talk about what I think is the decisive point of civilian risk mitigation. Now, it's not news that civilian risk mitigation is increasingly recognized as the decisive point of legitimacy of military operations. In fact, we could say that it's really the touchstone of legitimacy. And legitimacy, as we know, has increasingly become viewed as the decisive point to effectively achieving strategic end states. So in my view, this obligation to think about how to better implement the function of civilian risk mitigation is central to strategic legitimacy as well as moral legitimacy. And so I think that the armed forces, and especially the Judge Advocate General's corps of the armed forces, need to be evolving or perhaps regressing the understanding of both civilian risk mitigation as the decisive point for legitimacy and the role of the institution in enabling or facilitating enhancement of the civilian risk mitigation process. Now, I'm glad that Heather talked about the shift in the perception of threats and that the military has shifted away from its kind of almost total focus on counterinsurgency operations to near peer or peer on peer conflict. To me, what that means is that there has to be a recognition that the traditional notion of combined arms maneuver operations is increasingly central to the conduct or potential conduct of military operations. And I think there's kind of an ironic aspect to this. I started in the Army in 1983 as a tactical intelligence officer. And of course, what we were focused on was the risk of peer-to-peer conflict against the Soviet threat. And so all these notions of combined arm maneuver and mission type orders and air-land battle, this was all central to our development, our thinking, and the thinking of commanders on their function in military operations. That's kind of been resurrected, and we all know this. But what's different is that at that time, I can't recall any significant concern over civilian risk mitigation. I think there was at that time an underlying assumption that if there was a peer-to-peer conflict, it would be ugly and dirty, and there would be a lot of casualties, both military and civilian. And that was just an expectation. What's interesting to me, and I think challenging for the armed forces today, is that that expectation is completely different today. So what we have is a resurrection of the expectation of combined arms maneuver operations and near peer or peer-to-peer conflict, but we have the new expectation that legitimacy of those operations will continue to be defined in large measure by efforts to mitigate the risk to the civilian population. And of course, the looming problem or threat of the instinct of so many critics of military operations to engage in effects-based condemnations, or effects-based critiques is probably a better term, and in that way distort the true focus of determining whether or not a military command or a military commander has acted legitimately in the context of armed conflict. So what do I think is the decisive point in addressing this challenge? And I use that term decisive point because I was taught that a decisive point when you're planning military operations is the point that if you win it, you start winning and the enemy starts losing. The end state or the outcome becomes inevitable once you achieve that decisive point. In my opinion, the decisive point for civilian risk mitigation and the preservation of the reality and the perception of legitimacy are combat leaders. Combat leaders have to be grown and cultivated to understand their obligation to implement the balance. We talk about the balance between necessity and humanity in the law of war, and I'm going to come back to that towards the end of my short presentation. But I think that if the JAG institutions are being honest, they will recognize that for a variety of reasons, there's been a gradual shift of the perceived focal point of law of armed conflict implementation compliance from the commander and junior combat leaders to JAG officers. I mean, that's been influenced by COIN operations, by the abundance of information, the availability of time to make difficult decisions, the nature of the threat. And I happen to think also the increasing attention on the law by the legal community writ large, the academic community, the scholarly community, the legal community writ large. And so lawyers are instinctively the ones who are talking about the law and considering the law. But if you go back to the origins of the law, the entire notion of being privileged to engage in hostilities was premised on operating under responsible command. Of all the writing that I've published, I think the one that I'm most proud of is a very short article that appeared in the Review of the International Red Cross titled "Contemplating the True Meaning of Responsible Command." And what I did in that article was I emphasized my view that the historic link between LOAC regulation, LOAC compliance, and the commander was central to the entire equation. The commander was the focal point. That's why the privilege of engaging in hostilities was contingent on subordinates operating under responsible command. And I think that the doctrine of command responsibility as a mode of criminal liability for war crimes in many ways diluted the broader attention to what that term means. What does responsible command mean? When I was a student at the JAG school and when I was teaching at the JAG school, I would instinctively equate it with this doctrine of criminal responsibility. But I think it's much more significant. And what it means is that we have to cultivate combat leaders at every echelon of command, from platoon leader and platoon sergeant right up to division and corps commander or wing commander or joint commander, to understand that it is their obligation to ensure that their subordinates are prepared to navigate this complex and challenging environment where they have to be prepared to decisively employ lethal combat power, but also to ensure that they're doing it in a way that preserves legitimacy and the morality of the cause. So I think that the role of the commander and the notion of responsible command is much more than a legal obligation. It's a moral obligation to prepare soldiers for that challenge. And that's why I said earlier that maybe we should be evolving or perhaps regressing, because I think there were periods in history where it was very clear that it was the commander that was responsible to know the basics of the law and to ensure that subordinates were complying with the law. So I think there are two critical aspects of rethinking or evolving the role of the commander and the role of junior leaders in this equation. First, I think that it's worthwhile to reconceptualize how we characterize the LOAC balance, so to speak. We often think in terms of military necessity and humanity. I think what we should be thinking about and teaching is a balance between military necessity and the constant care obligation that's reflected in Article 57 of Additional Protocol 1. That's broader than just precautions in the attack. Constant care means credible combat leaders are constantly looking for ways to achieve their military objectives decisively in a way that mitigates risk to the civilian population. And if we grow leaders in a culture that emphasizes that that's their core responsibility, I think it will enhance legitimacy. And I also think that means that we have to reconceptualize the role of the judge advocate or the legal advisor in this equation. And by the way, I'll emphasize that I don't think this is reserved to judge advocate officers. I think paralegals are going to have to play an increasingly important role. When there is a legal dilemma, commanders and staff officers will look to the individual they associate with the legal institution. And that may very well be a non-commissioned officer who is a paralegal in the JAG institution. I think JAGs have to recognize that they're going to have to fulfill three vital roles in this equation. First, they have to be subject matter experts. They have to be genuine experts. They have to have a depth that certainly outpaces the commander. This is the function of any staff officer. Anybody who's been a staff officer other than a JAG knows that your function is to be an expert in your battlefield operating system. And the law is a battlefield operating system because it facilitates success. So JAGs have to continually enhance their understanding and their depth in the law. Second, I think they have to play a robust role in training and developing junior combat leaders at every opportunity they have. And it has to be creative, and it has to be mission and operationally focused training, but it has to be facilitated by these subject matter experts. And finally, I think they have to be prepared to be advocates of legitimacy. Now, I don't mean in the sense of an information operations campaign. What I do mean is I think there's nobody better equipped to articulate the reason why combat operations were in fact conducted legitimately, even if there are results that we regret, than judge advocate officers and paralegals. So there has to be more of an integration with the messaging, the strategic and operational messaging, and the subject matter experts in the law. It can't simply be handed off to a public affairs officer or entity because they don't have the nuance and the depth in the law that is necessary to articulate the credibility and the efforts that U.S. commanders and their subordinates have engaged in to ensure that they've acted legitimately under very demanding circumstances. And I'm over time, so I look forward to questions.
All right, everybody. Again, I'm Adam Oler. I'm going to build a little bit on what Jeff was talking about just a moment ago in the academic environment. I do have two unique caveats I need to point out. First of all, a number of you were here. Most of you were probably here and got to hear yesterday and got to hear General Mattis. And I just have to be clear here that when the fire alarm went off at General Dunlap's retirement, I was actually the exec in the room that day. But it was his former exec that had to warn General Dunlap about the fire. And that happens to be my wife. And that's because as soon as the alarm went off, I had in fact run completely out of the building as fast as I could. The second thing is, with all due respect to Don Zoldai's Tesla, I can't see stop signs when they've got snow or branches on them either. So with those out of the way, let me just touch on a couple things here about the perspective of joint professional military education, which is a fancy word for saying the senior level, or for me, the senior level graduate education that our students at the National War College and National Defense University receive. And it's important because about a third of the graduates from National War College go on to become flag officers or admirals, or of the State Department people, we tend to get a lot of folks who will go on to be ambassadors, chiefs of mission, DCMs, deputy chiefs of missions, and things like that. So a lot of what gets talked about during the LENS conference each year gets translated, addressed, or at least raised in the curriculum for these future senior leaders. And I want to just let you know about a couple of the things that are out there for those of you that are interested in writing about the applicability or the application of the law to the future interagency leadership that's coming up these days. And a couple of them that really stand out to think about. There is this question that's being revisited now because of some recent publications in the last few years about whether or not the law itself should be treated as an instrument of power, right? We typically have, since World War II, building on the Brits, talked about the DIME, right? Diplomatic, informational, military, and economic instruments. And now there's a big push to try and include law enforcement, law, fiscal, et cetera, et cetera. The problem with that and the challenge with that, and the reason why it's so important, is because once we start treating the law as a tool, as a means to an ends, right, as opposed to a framework through which to run challenges through in order to figure out what to do, what's right and what's not, it really does challenge the nature of the law and the understanding of it. And this comes up very, very practically in terms of what Jeff was just spoken about and what Lori Blank tends to write about, which is, or has written a lot on. And that is the law something that should be weaponized I'm not just talking about lawfare, but do we try to wield the law, change the law in order to achieve a specific ends? Or is the law a framework through which we try to decide what we should do and shouldn't do? And so one of the examples that comes up now, right, is the International Criminal Court. A lot of work being done on that, but it has become highly politicized, right, and changes what the law is from time to time to fit certain needs, which they have certain objectives that they may have, which then can lead to questions about legitimacy on the law. So that's one piece. Two other things, though, that are coming up a lot now are tied into, probably no surprise, the technology questions that are emerging, right? So when Jeff talks about casualty aversion, civilian casualty aversions, we are trying to get the students, not the JAG, not the lawyer students, but the students to own the decision process more than they have recently. Now, I will tell you that it differs among the services, but here's an example. Each year we run an exercise called Burning Sands up at the college, and then Lori Blank and I have run it in a number of law institutions as well. And when we do that, it's basically the situation based on what the Israelis went through in the Gaza Strip, where the students are asked to do three things, the operators, right? One is to seize the objective. Two is to minimize US coalition casualties so that we are able to make sure that the US will and the coalition will to remain in the fight remains. And the third one is to reduce civilian casualties on the enemy's side, right? And inevitably what the students will come back with is that they can get two of the three. And the reason why is because as the technology, videotape, smartphones, et cetera, have emerged, it is becoming incredibly difficult to be able to maintain the legitimacy of a combat operation, even when the airstrike or whatever the situation is, even when it is legal, right? So where we went from not considering too much or didn't think about civilian casualty aversion, it was taken for granted. Then we move forward, especially after the first Gulf War, in incorporating lawyers to try for legal reasons to limit civilian casualties and moral reasons. Now we are getting to the point that even when a strike is legal and morally justified, the imagery of that strike can be so emotive for people that are watching it that it almost doesn't matter or isn't the controlling aspect in terms of controlling piece in terms of deciding whether or not the strike should have happened or not. So if you look at the Israeli example, where the Israelis will destroy a schoolhouse without students in it, which have weapons in it that are being fired into Gaza or being fired from Gaza into southern Israel, absolutely legal for them to hit that target, right? Morally justified. Yet the fact that they blew up a UN schoolhouse does not, or in the image of the schoolhouse or any civilian casualties, almost undermines that part as well. So what does this all get to? This all gets to what is the utility of the military instrument of power overall. A lot of that depends on what the basis for the war is in the first place, but what we try to get the students to leave the college recognizing is that if they are going to recommend or be part of a debate about whether or not to use force, to use military force, they better understand that the nature of legitimacy, which doesn't change, I should say the character of legitimacy, whether something's legitimate or not, is becoming increasingly difficult to successfully advocate for. And then the last thing, just in a little bit of time, and we can talk about this in Q&A as well, but we're having a lot of debates up at the school about what the character of the next war is going to be, right? So the nature of war never changes. It's always violent, it's always interactive, and it always serves a political ends. But the character of war, who fights, how, and why, is constantly evolving. And we know throughout history that it's usually the side that can recognize war's changing character soonest that prevails, that's able to win. If you don't recognize war's changing character, that's the fastest route to strategic defeat. Well, there's a lot of discussion, of course, right now about how wars are being fought, right? And that's the technology piece, and that's at the heart of the American way of war, as Russell Weigley described it. But we're also going to have to start thinking about two other things. One, who is fighting the war now, right? Who is going to be the future warrior? Is it going to be the 18-year-old kid who goes out there with a rifle and fights on the battlefield or whatever, or is it going to actually be somebody totally different, right? The 16-year-old who's a genius with computers, or a genius on Twitter, or something along those lines, right? And the other thing too is why. Why are people fighting? If we start looking at recent events and the motives for why people are going to war, it comes down to fear, honor, and interest, right? Like Thucydides talked about. But is society changing? Is the interconnectedness between societies changing? Is the role of the nation state changing such that it's going to shape who it is or why it is that people are choosing to actually go to war? Now, these are very, very complicated topics, and the role of the law is not necessarily clear in them, but it is something that we have to work in into the legal profession to think about as well. And so the example I'll give is, I think most of us up at the War College, and again, always just talking for myself, I think most of us at the War College think that there is an excessive focus on traditional military arms in terms of what's going to create the effects in the next war, right? There's still a lot of discussion about $740 billion defense budget, the hardware that we're building, the aircraft carriers, the tanks, and all that. But what happens when in the next war, if it's against China or Russia, everybody's bank account gets drained, or the power grid gets shut off, or things along those lines. And so the character of war and who gets targeted in the war is going to change, we think, rather dramatically. And the problem is, are we being a little bit myopic? The very last thing, to come back to something that Jeff had talked about, we teach the students about the date of 15 April 1953, right? April 15th, 1953 is the last time US military personnel came under fixed wing manned air attack, right? No US military personnel has come under air attack since that date, right? I should say manned air attack. There have been ballistic missile attacks. That's important because it means we have owned the air since then, which means we have owned the ISR capability, which has meant we have had an advantage in communications and observation platforms for the better part of 2 generations. What we are trying to train our students to understand is that in the next war, that's not going to be the case. And for a legal perspective, from a lawyer's perspective, from a JAG's perspective, it means that the junior officer who is out on the battlefield is no longer in the next war, in all likelihood, going to be able to reach back to the JAG to even ask for advice, which means they're going to have internalized before they go into the next war what the basics of the law of armed conflict are. And the way to do that is to emphasize the training that they need to go through. They need to do reps and sets, as we call it, in the school. So those are a few things, just how we're trying to train the future senior officers across the professional military education environment, and look forward to your questions after the break. Thank you, or after the discussion.
Okay, thank you. I want to first, Charlie, thank you for having me again, even though we don't get the fun of all being together as we normally are. And I just want to add some thoughts on just thinking about some legal issues from another angle. And so I'll start by throwing out a question. Whose job is it to end war, right? And I'm gonna weave a bit of a story about some pressures this is putting on the law of armed conflict as we see developments over time. So conveniently, I often mention in class that it's so convenient that the news tends to track our syllabus. And so we have an example from just yesterday or the day before with the recent strike on the Iranian-backed proxy groups and militias in Syria. And if you noticed in reading some of the news stories, at least half, if not more, of the news stories and probably all of the blogs or tweets or things like that about the strikes in some way either mention the specific words endless war or forever war, or reference that concept. Oh, Biden is continuing the endless wars. Biden is not addressing the endless wars, etc. And so we are left in this space where, I mean, certainly we have been engaged in this conflict for closing in on 20 years now. And when I say this conflict, the challenge is, well, what exactly is this conflict, of course? And certainly those of you here in our virtual space today who are maybe under 30 have no conception of the US not actively engaged in some type of conflict somewhere. And this is obviously quite a long time. So when I say whose job is it to end war, I ask that because we're seeing the effects of this on the way we talk about the law of armed conflict, what we expect the law of armed conflict to do. And that is putting a lot of pressure on the law and perhaps driving some of its evolution in ways that may not be the most appealing. So we think about that question, whose job is it to end war? I can throw out some possible examples, some possible answers. Is it Congress's job? Surely, if we look at this from a domestic constitutional perspective, there's a lot to talk about there, but I'm going to stick more in the international space. Is it international law's job to end conflict? Not to end war big picture, but a particular conflict. Is it the obligation of the parties to the conflict to end it? Is it the law of armed conflict's job to help bring a conflict to an end? We don't really have a good answer to this question. It's not clear. And as we all know, when there's a vacuum, something rolls in to fill that vacuum. And it sort of seems like the sort of general discourse, has kind of put its chips on the law of armed conflict as a tool to solve this problem of conflicts that just go on and on and on. And so as we close in on this 20th anniversary of 9/11 and the start of the conflict with Al-Qaeda in Afghanistan and spreading elsewhere, we're seeing a lot of discussion about this question of forever war. And for a variety of reasons, the law of armed conflict is bearing a lot of the weight, even though it's not designed to end war. That's not what it's about. And it doesn't include any obligation to end war. So let me just tell this story a little bit quickly, just to frame out what's happening here. There's three factors that are really pushing on the law of armed conflict here. One is that there are very few legal rules, either in the law of armed conflict or anywhere else in international law, that help mark the end of conflict, let alone push for the end of conflict. We also have a lot of factual and strategic challenges in identifying an end to the types of conflicts that we're in right now. And we have a significant weakening, even emasculation of traditional tools that might normally push for an end to conflict. Let me just talk about each of those really quickly, and then we'll see what's happening to the law as a result. So the law of armed conflict has a clear framework, fairly clear framework for when conflict starts. That's essential for knowing when the law applies. Knowing when the conflict ends is equally essential for knowing when the law stops applying. But we have some identifying markers, but not really much to work with. The Geneva Conventions talk about the cessation of active hostilities for releasing and repatriating POWs. They talk about the general close of military operations, which is understood to be when the last shot has been fired. That's in international armed conflict. We don't really have a lot fleshing out exactly what those mean. In non-international armed conflict, the types of conflicts we're generally in now, there's very little, if any, guidance whatsoever in the treaty or customary law. So we don't really know. We have some theories. The complete defeat of one party, that would be a good sign. Some type of other factual indicators, like a lasting end to armed confrontations with no risk of resumption, or maybe a reverse of those start of conflict tests, what we think of as the Tadich test with intensity and organization. Do we back out of those some way? But the law pretty much just says it doesn't apply when a conflict is over. That doesn't tell us if we have to end it, how it ends, etc. As a factual and strategic matter, it's also very hard to know when a conflict with a terrorist group, even an insurgent group, particularly one that is extraterritorial, national in some way, very hard to know when it ends. And so we have a famous quip from General Petraeus at the start of the Iraq conflict, "Tell me how this ends." I think that continues to apply. There's a lot of uncertainty. What is victory? What is defeat of a terrorist group? And so it's very difficult to actually factually describe it. The last thing is we're left with weakened traditional tools. The elasticity of the 2001 AUMF has made it extraordinarily difficult for for Congress to try to impose an end. We don't have a lot of domestic political pressure. And interestingly, the strategic considerations of a conflict with a terrorist group may mean that it's wiser to manage that threat than trying to defeat it outright. And so strategically, the state might see it as a benefit to let the armed conflict persist because it's actually a better way to deal with the threat that is posed by that adversary, rather than outright trying to defeat it altogether, which we know is a difficult task when it comes to terrorist groups, which tend to morph, they go underground, they lie dormant, they come back, etc. So as a result, without a lot of these tools, without a lot of firm legal guidance, in some ways we find ourselves in a situation where we're asking quite a lot of the law of armed conflict. It's being looked at and asked to achieve goals that are only really remotely related to its core purpose of regulating and the conduct of hostilities and protecting persons during conflict. There is international law that seeks to end war, big picture, that's the jus ad bellum. But its job also is not to end wars, specific conflicts. It tries to end war, big picture, by regulating and limiting the start of conflict as a preventive measure. But it doesn't have a lot of constraints on the extent and duration of conflict. And so, again, LOAC kind of is left as the place where we are looking. One way this is happening is we see a lot of efforts, and this ties into some of the conversation both that Jeff and Adam were both having. We see a lot of efforts to essentially rely on the law of armed conflict to make conflict more palatable, right? To almost sanitize it. That's not the law of armed conflict's job. It is to protect persons. It is to minimize harm to civilians, but it's not to make conflict look like, oh, it's okay if it lasts a really long time because we've tightened the constraints and we've made it look a lot less violent and a lot less brutal. So it's okay to have conflict for a long time, right? In essence, asking the law to legitimize a protracted conflict by making it look a lot less like what we fear war is like. Another concern, I'll just mention one last thing as I hit the end of my time here, is in essence, we understand war as an extraordinary circumstance. And it's the exigency of that extraordinary circumstance that triggers the law of armed conflict and its different rules than peacetime. But if conflict continues and we fail to have the tools to end it, then the law of armed conflict also kind of becomes perpetual. And we lose the extraordinary nature of both conflict and of the law of armed conflict. So I'll leave it there. Happy to hit any other points during the Q&A. Thank you.
Hey, this is Lieutenant Colonel Neiman. I am not being allowed to restart video. Maybe that is on purpose. All right. So we have had a lot of really great questions already, and it's hard to sift through them. And I know that we are going to run out of time because we could talk about this all day. I'm going to paraphrase a couple. I'm not sure what's going on. It's not allowing me to start my video, so we're going to blaze through that anyway. I am going to paraphrase a couple of questions that we've had that relate to Jeff's comments about, I have no idea. Sorry about the tech issues, guys. I can just see Lori waiting patiently.
We hear you.
All right, I can see Jeff. All right, I will figure out the video thing shortly, whatever the issue is, but I do want to jump to the questions. We've had a lot of questions regarding Jeff's thoughts about civilian risk mitigation and how that may have become an increased focus over your career. And so we'd like to ask you to address whether or not you think that increased focus is really germane to the times that we're in, and whether or not that decreases in the event of large-scale combat operations. So over to you, Jeff.
Okay, first I do have to make a point to Adam. Having just lived through 57 hours of no power because the grid shut down during the coldest period in Houston in 50 years, I think that's a clear violation of Common Article 3, Article 75 added up. We cannot allow that, Adam. Whatever happens, cannot allow that again. I had to take a bath in my swimming pool when it was 37 degrees. Okay, so yeah, there are a number of questions that I think are challenging the notion that this emphasis on civilian risk mitigation may be, or suggesting it may be transient. It may be linked to the nature of operations. So maybe the fact that when I studied how to defeat the Soviet threat, and Charlie was advising commanders and Adam was advising commanders preparing for airland battle and deep strikes, the reason we weren't focused on civilian risk mitigation was because of the existential nature of the threat we were facing. Here's my view in response to that and the several questions. Nothing we do is going to change the expectation that armed forces can conduct their operations in a way that endeavors as best they can to mitigate civilian risk. And again, that's why I started by emphasizing, I don't use the word civilian casualty prevention or aversion. I think instinctively any moral commander should be averse to causing civilian casualties unless they're unavoidable. If they're unavoidable and consistent with the law, then it's a sad and tragic consequence of conflict. I've written on this topic specifically. I'm looking at an article on SSRN, Humanitarian Regulation of Hostilities, the Decisive Element of Context. Lawyers know that in any other situation when we're assessing what is or is not reasonable, context plays a decisive role. So do I think that there is going to be a greater tolerance for effects of combat that result in civilian casualties? Yes. Do I also think that our enemies are wise enough to know that that's a strategic Achilles heel? And by the way, when you're talking about coalition operations, it's a wedge you can drive between coalition partners because different governments are going to have different levels of perceived tolerance for perceived indifference to the civilian population, and the enemy knows it. So we have to be prepared for this. And Adam makes the point, preparing for it doesn't mean that we avoid engaging in decisive combat operations and compromise the operational and strategic end state of the mission. Prepared for it means that in the context of the type of operation we're dealing with, we do what is reasonable, and then we're ready to defend those actions in the media space and in the diplomatic space by showing all of the things we did up front to mitigate risk, which begins with training officers and non-commissioned officers at every level to have a sense of moral and inevitably legal obligation to do what they can under the circumstances, as difficult as it may be, to mitigate risk. And the value of that is when we can't avoid it, it becomes more credible. Our actions become more credible.
If I can just jump in on this as well, I think looking forward, we shouldn't just confine the conversation about how to prepare for this, how to deal with this question to the military space. I think the discourse and the space of legitimacy when we're talking about military operations and civilian casualties and risk mitigation encompasses the much broader discourse. And we are in a place where, in essence, governments and militaries have trained, not on purpose, but have inadvertently trained the advocacy community, the academic community, and the broader media, etc., to expect this heightened attention to civilian harm, this ability to use every technological tool at disposal to minimize civilian harm, and that is the touchstone of the conversation, even if it shouldn't be, right? Or it should be, either way, right? And so in essence, there is a need to almost try to retrain that conversation in the context of peer-on-peer conflict, high intensity conflict, etc., to be able to have a productive conversation about the application of law in those situations. Because just as the military is thinking about how to transition from a COIN environment to a peer-on-peer environment, including things like how do you unconflate the law and policy that has happened over the last several years, the last decade and more. We need to have that same conversation outside the Department of Defense, outside the military, in the advocacy community, in the academic community, because the interplay between these communities is really important. But if it's totally stuck on these two different tracks that never cross, we're going to be constantly in this space of, information about what happened and automatic calls that it must have been illegal. And the two sides are going to stop being able to have a productive conversation. So I throw that out as a broader kind of rejiggering of the conversation as well.
All right, I'm back. Oh, and am I talking over Adam? I'm sorry about that. Adam, go ahead. We'd love to hear what you have to say.
So I think this gets into another one of the questions that had been asked by the group too in the chat room. And also, while I'm looking at the chat room, let me thank my friend Harvey Rishikoff for giving me the same level of support he has for years. I ran out of the building. There was a fire. It's not my fault. It was the right thing to do. Okay, so I think Jeff's point about context is so vital to understand that it really can't be overstated. And the word context, right, in Clausewitzian terms, which we really do emphasize, is Clausewitz said the most important thing to do when embarking on a war is to understand what kind of war it is upon which you are about to embark or be dragged into, right? Legitimacy at its most basic has three things, right? The basis for the war, right? Think of that as the jus ad bellum piece, right? And the more that the basis of the war is deemed to be legitimate, frankly, the more freedom of action you're going to have, or the more freedom of maneuver you're going to have. I'll put it bluntly, the margin of error is broader, as awful as that may be, in the eyes of constituents, the enemy's constituents, our constituent, and the global constituency. Doesn't mean it's right from an informational aspect of it. The second one is the conduct during the war, which includes whether or not you are succeeding in the war, but also the behavior in the war, whether or not war crimes are committed, the footage that comes out. And then the third one has to do with international support. So where Clausewitz was always concerned about, he'd talk about his two trinities, right? Us and the enemy. There's a third one, the global piece. So I think that that's important. What I'm worried about, to get to the other question on here, is that I think that the character of war, the COIN war, has not only lulled us into a certain sense of security, but has given us the idea that we can change through the use of the law, through the law, change war's nature, right? And we can't. And war is always violent. And if a country perceives itself as being in an existential war, it's going to do whatever it needs to and use whatever Achilles heel it thinks we have. And if it thinks that our that global support for their actions can be diminished by making it look like we are killing civilians, they're going to do that, right? And so afraid that the change in information technology has greatly incentivized our enemies' willingness to and desire to exploit civilian casualties as much as possible, regardless of whether they were legal or not, which makes it even more important for anything we do to be legal so that we can win that battle for international support. The other thing I'll just close with is, Lori's point here about the discussion is so important, that while the character of law changes, right, the law really doesn't. The law of armed conflict really doesn't. And I think that it's important. I mean, it can evolve a little bit here and there. We can talk about post-war obligations and whatnot, but we have to be careful that it doesn't get weaponized, right, by itself. The LOAC itself doesn't get weaponized. And there's a temptation to do that, right? The law is the law. It's a framework. And the last question that's on here, I think the frameworks that we need are already there, right? We just have to recognize that reality is going to change the character of war, and inevitably, if there's a major peer-on-peer competition or peer-on-peer war, the level of casualties and destruction is going to be the worst ever, even short of nuclear weapons being used. I mean, I think that's what's going to happen regardless of what the law might be. So on that happy note, I'll hand it back to you.
Yes, sir, and I think that's a great point. And it touches on what Major Traeger was talking about regarding law versus policy versus common understandings, and whether or not we're building or whether or not we're changing the rules based on our behavior. And I think that's important in the landmine area. And I also, it also touches on a number of questions that we've got regarding our allies and whether they are signatories of different treaties, and whether playing by different rules makes a difference. And so I'd like to pass it to Heather to have her talk about what law versus policy, like you just mentioned, sir, and the challenges to interoperability.
Yeah, so I mean, I think it is definitely a real concern when we're operating in a joint environment with, the law is what binds us all. So we're operating in the same place. And some of our partners are, with regards to, for example, landmines, are signatories and party to the Ottawa Convention. So, and when we reverse our policy and we are not bound by the obligations under Ottawa, then it becomes a question of, can we operate together? As I mentioned in my presentation earlier, a lot of our partners have actually, done reservation statements when they signed on to Ottawa that they can still operate with those who use the landmines. So that does quell some of the concerns for operating together in a joint environment. So they may not be using them, but they can still operate with us. But sometimes the legal obligation could actually prevent a joint partner from operating with us if we are not bound by the same legal obligations. Now, if it's just a policy consideration, then that doesn't come into play. State responsibility is not triggered by operating with somebody who has a policy restriction, such as like the rules of engagement and stuff. In joint environments, many of the nations have different rules of engagement, and most of those are policy considerations prohibiting, the use of force in certain situations. But those are just policy considerations, and they don't trigger a state's responsibility operating together when the policy is not similar. But the law needs to be similar when you're operating in a joint environment. Otherwise, you can trigger a state's responsibility if you are doing combined operations with another nation that is violating the law of armed conflict.
Thank you, Heather. We've got some specific questions. One for Lori regarding the UN Security Council's role in helping to bring conflict to an end. I'd like to broaden that, Lori, and give you a chance to touch on other organizations, what roles those might have, and what that means for their relationships with the military community.
Well, I think I see there was also, I'll touch on one of the other questions in there about whether we should have more law for ending conflict. And I think, like anything else, we often expect that, the existing practice or incentives will continue to make things happen in the way they've always happened or the way they should happen. And then that gets upended. So, for example, if I were to make a extraordinarily stereotypical and generalized statement, with that caveat, I might say that traditionally, war was something that leaders and countries and parties involved in conflict took pride in winning and ending, right? That might have, that's not an unreasonable statement to make. Obviously, it does not apply to every situation. We can poke massive holes in that statement, but let's just start with that. That doesn't necessarily seem to be the case in the same way, right? Post 9/11 in particular, it seems to be that staying in a state of conflict is not even okay, but it is desirable. It provides a more permissive set of authorities from a legal perspective. It provides a range of action. And so we're kind of in a different descriptive space in that sense than we might have been before. And that's why some of these questions and pressures, I think, are kind of bubbling up. I think there's a role for lots of institutions. I don't think we can generalize across all conflicts. I think in the same way we might talk about the instruments of power. A nation should bring all instruments of power to bear, and the right ones in the right ways, pulling the correct levers at the right times in order to enhance and protect its national security. I think the international community and individual countries need to think the same way about the various levers or tools that might be available to help bring conflicts to an end. One of the challenges that we face is that many of those are not as effective as they might have been in previous situations. And that's one of the situations that we find ourselves in, particularly when you have an adversary that nobody really likes, that nobody's on their side. There isn't anybody, for example, if you pick ISIS, and to me, ISIS is the example that tends to kill most theories. I call it the really, really bad actor theory. Not everything holds in the same way, but there don't seem to be a lot of actors that are pushing ISIS to take certain action to, if we were to go back a couple of years, to bring an end to something, to stop its conduct, and so on. Everybody viewed them as so reprehensible. Nobody was saying like, okay, we'll try to engage with them and promote, their engagement in this negotiation or that. And so we have some of that going on, which is a challenge. I think the UN Security Council, of course, in an ideal world, would be heavily involved in trying to bring conflicts to an end. We have political reasons why that doesn't happen. I think there are limits to the ability to have law that is going to firmly state how or why a conflict should come to an end. The reason we have limits is because the chance of having states sit down and negotiate a treaty to that effect are probably less than zero. And so I think it requires creativity and entrepreneurship and, a lot of clever thinking and use of all tools at our disposal.
Thanks so much, Lori. And I think Colonel Oler also wanted to weigh in on the question.
Just briefly on the question about the utility of international institutions and especially the UN Security Council. The fact is that the liberal international order, right, the post-war order that created the UN and a lot of these institutions is not, if it's not gone, it's disappearing quickly. The chance of the Russians or the Chinese approving something, not blocking something at the UN. Lori mentioned ISIS. They wouldn't even agree. They blocked legal action against them to the ICC, right? So I think for strategists, we have to understand, and we teach this at the school, that relying on international institutions for war resolution at the strategic level, at the highest interstate level, they can provide a room to meet, but they're not going to drive outcomes nearly as much as they used to. And that's part of the problem with great power competition. That said, those organizations are also indispensable in taking care of people. You go back, I mentioned the liberal international order. None of the things the UN does now was being done prior to 1946. It wasn't. We had no idea where starvation was occurring. There was no World Health Organization. There was no monitoring of anything, population movements, all that. So that, of course, that's indispensable for preventing war and helping mankind. But I think the days of looking to the UN Security Council resolution as a helpful means to ending conflict or legitimizing what we're doing, it's gone for a while. So again, just trying to bring up the positive wherever I can.
That's great, great and always appreciated. We've got a question regarding whether or not we're doing enough under the Low Act to protect our own civilian populations, such as emphasizing perhaps a stronger passive precautions obligation. And then, maybe the idea of how that relates to justified strikes that hurt civilian populations, whether or not we think that is going to be revisited in a near-peer conflict with significant loss of life on one side or the other. We've talked about the topic a little bit, but if anybody wants to take that, that is not addressing.
I'll take it because it came from my friend and co-author, Jim Shetler.
It's a great question.
Yeah, hi, Jim. I think the issue of passive precautions is, I think the reality is it's principally a tactical focus, because in reality, we don't have the Pentagon in the middle of nowhere because it needs to be near the seat of power. Now, will that start to change with technology? Has our last year of Zoom life suggested that it would be more advantageous to demonstrate our commitment to protecting our own civilian population by removing vital assets to areas where they're more remote? I think it's unlikely. At a tactical level, it becomes very difficult, especially if what you're trying to do is to demonstrate the enemy's responsibility for the civilian casualties that the world thinks you are responsible for. This is an article I wrote called Guarding Against the Conflation of Cause and Responsibility. Lawyers know that direct cause is not always the source of legal responsibility. We're all taught the notion of proximate cause, and whether there's an intervening event that bears responsibility for an outcome that was directly caused by an individual. I think that same concept applies in conflict. And we know this. In many cases, civilian casualties are caused by the unwillingness of the enemy to take any effort to mitigate their risk, and also to actively seek to exacerbate that risk. How do you demonstrate that responsibility to an international audience? As Adam says, that's a reality. It's an aspect of strategic legitimacy, and that will instinctively gravitate towards images and simply extrapolate whoever dropped the bomb or shot the artillery shell is responsible. So I think Jim has a good point. In a way, we compromise our credibility in condemning that type of behavior when the enemy can point to the location of the Pentagon or the National War College or whatever it may be, and say, well, look, you don't seem too interested in removing your targets, and your assumption is you're always going to play away games, but the law is the same for everybody. I think for me, the more important focus should be, particularly for judge advocates, coming up with rational criteria for identifying and quantifying the enemy's failure to comply with their own passive precautions obligation. That's hard to do. I was on a review of the 2014 Gaza conflict with 5 retired 3- and 4-star generals from the United States. And one of the things that really bothered them was where Hamas was locating its missile and mortar launch points, because it appeared that they were deliberately locating them in the midst of the civilian population. But one of the generals, Major General Jones, who had been the CENTCOM chief of staff, said, the problem with that is that if I were in that tactical situation, then I would seek to exploit the environment I had. And I can't automatically say that just because you have a mortar position in the midst of civilians, you violated the law. Now, what he did say was, when there's a mortar position in a kindergarten playground and there's an empty lot across the street, then that supports only one rational inference, is that you're using the location to shield. But I agree with Jim. There has to be a lot more attention focused on how we give meaning to the Article 58 notion of mitigating civilian risks through passive precautions.
Jeff, thanks so much. Colonel Oler has a couple of thoughts on that question as well. Over to you.
I just wanted to wrap up from my perspective with the difference with these things that we're talking about. These are extremely exciting questions. They're really interesting questions, and they are vital to the future, right? And so for people in the audience that are thinking about whether to go into public service or go into national security law, I would just encourage them to do so, right? And national security law, to get into this more all the time, it's not necessarily being in the military. The role of law enforcement, the role of the State Department attorneys, Treasury, Customs, all of these folks, are all ways to get involved in national security law. And as one of the last questions here points out, talking about the broader battle space here, absolutely, we have got to start integrating the interagency and industry and the country as a whole in order to be able to answer these legal questions, because the next battlefield is not going to be on the battlefield. The whole space is going to be the battle space. And we haven't really seen that in our own time, in our own country in 150 years. So I would absolutely encourage people to dive into this and to, pick up the baton and run with it, because it's vital. So thanks.
Thanks so much, sir. We are in lightning round mode. We got 4 minutes left, and I'm going to give Lori a chance to crack on this question as well.
Sure. So I just want to jump back on the question of passive precautions, and Jim Shetler, when you asked the question, I'm sure this was in your mind, but I want to throw out the importance of thinking about stuff we can't see so well, like space and cyber, which raise really interesting and hard and different questions about things like passive precautions. And for example, what kind of precautions does the US or another state need to be taking with respect to space assets that carry out both military and civilian capabilities? And how do we think about that? And we're going to be we are in a space, and we are going to continue deeper into a space where the nature of civilian harm will be less obviously connected to the acts that we see, and we need to make sure we understand that. And so the last thing I'll say, kind of a little bit building on that, but more broadly also building on what Adam was saying, is that we see an enormous amount of discourse about the law and about conflict, much more than ever before in the past, which is very exciting. But it also requires that anybody working in this field maintain that continually satired lawyerly habit of being precise and sticking to definitions and categories and all those things that lawyers are panned for. But it's important. There are reasons why the law applies particular ways in particular situations. And we have to be able to understand that in order to then use it for the hard questions where things get conflated and complicated. And so those of you, particularly students, young professionals who are thinking about getting into this area, sharpen your tools in your toolbox. This is a very exciting area, but don't forget all those sort of basic lawyerly tools that we have to rely on. Thanks.
Thanks so much, Lori. And let me take this opportunity to thank all of our panelists. We're going to end right on time. There were a lot of thought-provoking issues that we talked about today, and a ton of questions that we didn't get to. So I hope that all of the national security law practitioners and aspiring practitioners out there do take the opportunity that Colonel Oller talked about to engage with the profession, to continue asking these questions, to write on these topics, and to really stay focused on these issues that were raised. So
Can I
thanks.
make one quick comment, Amy?
Sure.
I want to take an
You got a
opportunity to thank you for managing this, and I want to take an opportunity to thank General Dunlop for having the wisdom to give active duty judge advocates such an important platform and opportunity. I can tell you, when I was at the JAG school, the opportunity to participate in something like this with 300 participants tuning in would have been incredibly exciting, but also a little bit daunting. So well done, Heather. Well done, Amy. You are credits to the JAG Corps, and make me proud to know that I'm a alumni of the institution that you continue to represent so well.
Thanks so much, Jeff. And yeah, absolutely. We all want to thank General Dunlap for giving us this platform and the ability to engage. So I will leave it there, and back to you, sir.
Unmute.
Well, thank you, Amy, and thank you all. What a fantastic panel. What I really loved about it is I got so much to think about myself. And, you think you know about these areas, but when you hear this kind of expertise, it really is stimulating. Very, very interesting panel. And by the way, I just want to throw out that I'm always welcoming blog posts from our audience and from young JAGs. Heather, I'm looking right at you. So, and Amy, and really do want people to know the kind of expertise that we have in our armed forces and among our military lawyers. But I welcome everybody, and really very impressive panel, very thought-provoking, exactly what I wanted, by the way. So we have 10 minutes or a little bit less than that before we will welcome the president of the ABA, along with some other experts, Mr. Pira and Judy Miller. So stand by, 10 more minutes, and we'll see you very shortly. Thank you.